surprising and somewhat unusual. Maybe at some psychological level, this helps justify to himself dealing with this, a defendant like Jeffrey Dahmer.
Good evening, I'm John Callaway, and welcome to Chicago Tonight. Do you believe that someone who kills 17 persons should be treated as someone who is mentally ill and be given confinement and treatment? Or do you believe such a person might know exactly what he was doing and should be treated as a criminal and be executed or given a life sentence? Tonight we will explore these questions of mental illness, crime, and punishment with the attorney who's representing Jeffrey Dahmer in the Milwaukee murders case. We'll talk with Gerald P. Boyle right after this background report from Chicago Tonight correspondent CHITRA RAGAVAN.
As to counts 1 through 8, you are charged with first-degree intentional homicide, which carries a life imprisonment penalty.
Television cameras captured many close-ups of admitted Milwaukee serial killer Jeffrey Dahmer last week, as he appeared in court to face 8 additional counts of murder. But stare as one might at Dahmer's face, so calm and composed, one couldn't fathom his mind or soul, or comprehend why he butchered young men.
To imagine that any human being, any civilized human being in civilized society could do something as gruesome. Other than that, it's inexplicable.
Some have been comforted by the idea that Dahmer must be crazy to do such terrible things to people, because no sane person could treat another the way Dahmer did his victims. DePaul University law professor Donald Herman says that given Dahmer's confession, his lawyers have little choice but to use mental insanity as his principal legal defense.
In some states, for instance in Illinois, we have a verdict which is called guilty but mentally ill, which technically provides an opportunity for the jury to find that the person committed the crimes, does not satisfy the insanity offense, but needs mental treatment. In effect, the defendant is then returned to prison after being treated to serve out the remaining part of the term. But from what I understand in Wisconsin, that's not an available alternative. So I think that they're pretty much left with the insanity defense.
However, says Herman, Dahmer's lawyers will have their work cut out for them, because historically serial killers have been unsuccessful in pleading mental insanity.
The jury tends to be more sympathetic with individuals who have aberrant behavior, who seem to have a mental problem, but are not so threatening and so different from everyone else that they feel they need the protection of a prison to have society protected rather than having mental health treatment. So someone like John Hinckley, who's like the boy next door, is more likely to be successful in an insanity trial than is someone like John GACY or Manson.
Or Jeffrey Dahmer. If Dahmer's lawyers argue mental insanity, under Wisconsin law, there will be 2 phases to the trial.
The state has to show before anything that the defendant committed the acts and had the requisite intent to kill. Then the defense will show the defendant not only was mentally ill, but that as a result of the mental illness was unable to understand the nature and quality of his acts or to know what he was doing.
That's often difficult to prove in cases involving serial killings, according to U.S. Attorney Fred Foreman. When he was Lake County, Illinois State's attorney, Foreman prosecuted death penalty cases in which an insanity defense was used. He declined to comment specifically on Dahmer because it's a pending case, but talked about the methodology of serial killers.
You find that a serial killer is very meticulous, he's methodical. He oftentimes selects the same type of victim and really is very conscious of the fact of being caught. Is not the type of person that is deterred oftentimes by other types of penalties that would deter some people from committing their crimes. So many times when there's so many meticulous details that go into a crime scene with serial offenders, it's very difficult to establish that the person did not understand the difference between right and wrong.
Did Jeffrey Dahmer understand what he was doing was wrong? DePaul University's law professor Donald Herman thinks so. Herman says the case of the 14-year-old Laotian boy who almost escaped Dahmer's clutches shows that Dahmer knew he was doing something wrong and did it with great deliberation.
I think the case of the juvenile who escaped from his house, who was in the hands of the police with Dahmer having gone out to have a beer, coming back and dealing with the police and trying to get the individual released to him and then killing him, shows that this wasn't something that was done on an impulse or some kind of driving compulsion, but it had some kind of calculation and certainly a measure of control on the part of the defendant.
Jeffrey Dahmer has forced the people of Milwaukee to take a good hard look at their city with its social, economic, and racial problems, the performance of the police, the parole officers, and others who let Jeffrey Dahmer fall through the cracks in the system. Their soul searching will undoubtedly continue as the Wisconsin criminal justice system begins to record and analyze what Jeffrey Dahmer says he did and debate whether or not he should be punished for his crimes. For Chicago Tonight, I'm CHITRA RAGAVAN.
And now let me introduce the attorney who is representing Jeffrey Dahmer, Mr. Gerald P. Boyle. Welcome to Chicago Tonight.
Thank you.
When is the last time you talked with Mr. Dahmer?
This afternoon.
And what is his mental state? What's his attitude now?
Well, mental state is kind of not a very relevant question, except as it relates to my ability to consult with him.
I meant that.
So I'm able to do that. And that means that, in my opinion, he's legally competent to stand trial and that at this time, and that he understands what's happening around him, and he's able to assist me in doing my job on his behalf.
I had heard in one of the news accounts somebody said he was very depressed. They described him as deteriorating, really in a bad mental state. You're not describing that person as you've just described him.
Well, I don't know how other people could make that statement because they're not in touch with him. I find him from day one, and I said that on day one, he's in a very deep state of despair. I use the word anguish to describe the young man that I'm talking to. But right now we're in a professional, business-like relationship where I ask him questions and he responds to me. And we have a flowing conversation not unlike what you and I are doing right here. And that's what a lawyer is supposed to do, and that's what I've been doing.
You've talked about the very serious process that's going on now, pre-trial. Tell us about that process and how far into it are you? What are you doing?
Very early stages of a criminal case right now. He has been recently charged. Soon we'll be making a decision on whether or not there's going to be a preliminary hearing. Unlike your state, we have a preliminary hearing on every felony. The defendant may waive the same. Only the defendant may waive it. If there is not a preliminary hearing, he will then go up for arraignment, at which time the plea will be entered. And motions are then filed. Some motions have to be filed as a matter of law, and then the matter will be set for the hearing of the motions and then the trial.
And will you seek a preliminary hearing?
I don't know yet. That's a decision I'll be making early part of next week. Preliminary hearing, just so you understand, is only for felonies, and it's only to find whether there's probable cause to hold someone for trial. Now, the criminal complaint reflects that Mr. Dahmer has made many statements admitting participation in incidences. There has been identification made by a forensic odontologist as to the victims. So I have to make a judgment as to what I'm going to learn at a preliminary hearing. If I'm not going to learn anything, then I won't have one. But that's a decision only Mr. Dahmer himself can make, and it won't be made until we get on the eve of that date.
And at this stage in the proceeding, do you have psychologists or psychiatrists waiting in the wings to talk with him, or are they already talking with him on your behalf?
What I did, John, and I announced to the press the first day, my discipline happens to be the law, not psychiatry. I hired a forensic psychologist well known to the Milwaukee County courts, very well respected. His name is Ken Smale. He is the conduit to any and all psychological involvement of psychiatrists. We've had offers from all kinds of psychiatrists, all kinds of psychologists. His function for me is to find out who we're going to use, and then I'm going to translate from what I learn whether or not we have a plea to enter, which plea will be entered at the arraignment and will be made known only at that time, because that's what the canons tell me I must wait for, and that's when it's going to be done.
You can't be sitting on a program like this and say, John, tonight I can tell you we're going to enter the thus and such plea. That is not appropriate.
It's not only appropriate, but I wouldn't be able to do it even if it was appropriate.
In other words, you haven't made the judgment yet.
I haven't made the judgment yet.
Are those of us who are following this case in the press, as far as you can tell, being well informed with respect to, I mean, should we take the police's word when they say he confessed to 17 murders? Should we, number one, should we take the police's word? And number two, if he did confess, were they constitutionally and voluntarily obtained?
Well, first of all, once again, the rules governing lawyers' conduct are very strict. I am limited to the written document. The written document is something that is sworn under oath. That written document says that Mr. Dahmer, he used the word confess, made admissions.
Made admissions.
To 12 homicides. Now, that's under oath. Now, the next question is whether or not it's constitutionally antiseptic, whether it was voluntary, whether or not he was properly Mirandized. In our state, based upon the United States Supreme Court rulings, and our state had that even before the Supreme Court came down, there must be a hearing. You don't even have to ask for it. There must be a hearing to determine whether or not the person was properly advised of their rights, whether or not under all of the circumstances the statement was voluntary, whether or not it's trustworthy. If the judge decides that it's trustworthy, then the jury also has a chance to make that decision, but it's admissible then. And then the weight is to be given by the jury to that statement. All of that's going to be done in a normal process of events.
How soon after the admissions were made did you start to represent Mr. Dahmer?
Well, about 12, 15 hours after I think he was taken into custody.
And had you been representing him prior to that, would those admissions have been permitted?
There is no way in the world I'm going to answer that question, because I can't. You see, the Fifth Amendment right isn't my right. The Fifth Amendment right is the client's right. So therefore, it would have been Mr. Dahmer who would have made the decision based upon my advice.
But can you, as a citizen, agree with the layman who says, well,
I don't know why there is any question about it at this juncture, because eventually the only thing left is whether or not he was properly advised of his rights. Somebody is going to find out about that, not too distant future, and whether or not it was voluntary.
Is there any indication at all that he wasn't?
Well, I can't get into that.
You can't get into that.
The canons, I'm telling you, they're so tough that you can't cross the line.
Okay.
You can't. I'll tell you how perhaps one could argue even absurd. If you're accused of a crime and you hire me, I can't say that you told me you were not guilty. I have to do that in the courtroom. While the prosecutor can write out your indictment and throw in anything they want, I can't say that you're not guilty. I can say you're going to fight it in court, I can say that, but I can't say you're not guilty. So that's the problem, and I follow those rules very strictly.
You first met Jeffrey Dahmer in 1988?
Sometime around then, his first case, yeah.
Tell us about that case. He was charged with?
Charged with sexual assault of a youngster.
How did he come to get you as his lawyer?
Lawyer suggested to his father that he hire me. And a lawyer is supposed to accept cases. He's not supposed to reject them unless he has a conflict of interest, whether it's a popular matter or an unpopular matter. So I took the case.
And did you plead him guilty, or did you go to a jury? How did that case work?
Pled him guilty.
You pled him guilty?
That's right.
Did you get to know him at that time?
As well as I get to know most of my clients, yes.
And how well is that?
Quite well.
How much time did you spend with him?
Oh, I don't remember that. That was 4 or 5 years ago.
What'd you make of him?
Well, I felt he was a young man who needed some help, and I think that the court recognized that. And the court gave him, you know, a lot of people have great crystal balls and said that this is what I would have done if I had been that judge. I think the sentence was a very tough sentence. And let me tell you why.
Well, let's say what the sentence was first. It was 8 years.
8 years stayed.
Stayed, which means?
That means step out of line one time and you go right to prison for 8 years. You don't go back to a judge.
But it was stayed.
It was stayed. He was placed on probation for 5 years.
All right.
That means any time in the course of that 5 years, if he crossed the line, broke any of the rules, prison for 8 years. Don't go back before the court. He was placed in a house of correction for 1 year.
That's a work release program,
it's
right?
Work release. Now, this is what this means. That means 12 hours a day you're in, 12 hours a day you're out. 1 day a week you're there 24 hours. You don't live in the greatest conditions in the world. You get up in the morning, you got to go to work, You don't get to stop, you don't get to drink, you don't get to visit your friends, you don't get to go home.
You get any treatment?
Let me finish. After his year was up and he got 2 months credit because he never ever did anything wrong, he was put into a program to help him with his, quote, deviant behavior, quit quote. During the year, he was under the scrutiny of the people at the House of Correction. I often tell people who have that option available, they're better off going in prison for 3 years. It's an easier sentence.
Why?
Because it's very difficult to get up in the morning, 25 below zero, get on a bus, go to work, come back into a very, very, the environment's a very difficult environment living in that jail condition in the House of Correction. Whereas in prison, you have some freedom, you get to go to school, you get to do some work, you get some recreation, and you get paroled faster.
But tell me about that part of the program that dealt with his so-called deviant behavior.
Well, the judge ordered that the probation department work with Mr. Dahmer and get him into a program that could help him with whatever deviant behavior the psychologist felt he had. Lawyer loses touch with that. That's suddenly when a person gets released into the probation system, lawyer doesn't have any continuing discourse with the client. Basically, he's finished the moment of the sentence. Case where they're inside, you get calls from time to time when they have problems, but basically you lose touch with them after they go into the prison system or the criminal justice system.
You were a prosecutor for 4 years in the Milwaukee County system, right?
And I'm proud to say I was a chief prosecutor for 2.5 of it.
Did you take on as a prosecutor any of the cases like the one that you defended Dahmer on in '88?
I did. I prosecuted the first Milwaukee County serial killer ever. Young man who killed 2 little girls and tried to kill a third. About every second week he was menacing the area. So yes, I did have that experience.
And did you take on any cases which were like Dahmer's in the sense of the Dahmer '88 charge of deviant behavior?
Hundreds of them.
When you were a prosecutor, if I had said to you then, do you believe that this kind of deviant behavior can be dealt with successfully, either in probation, prison, or any of those ways? How would you have answered that question?
Yes. There was a different law in effect then. If you did the kind of crime that Mr. Dahmer did in 1965, 66, you were automatically studied for 60 days at Central State Hospital to determine whether or not you were sexually deviant. If you were found to be sexually deviant, you were committed to the department until psychiatrists said the deviant behavior was cured. If you were found not to have been a sexual deviant, you were brought back into court and you were sentenced as Mr. Dahmer was in 1988. For some reason or another, they did away with that. I thought it was a mistake then, and I think it was a better system, because then they had a better ability to determine whether or not the person in the system needed deviant behavior on an inpatient basis, so as to say. They did away with it.
Do you have any regrets about getting that sentence which enabled him then to get out and be in society and to allegedly kill?
Oh, my goodness gracious. I must say that I am a lawyer. I take an oath to represent honestly, as best as I can, the person who has hired me. I have that commitment. As long as I don't perpetrate any fraud on the court, say something that's not true, of course I don't have any regrets. Any more than the doctor who might have taken care of his appendicitis that allowed him to live would have any regrets on not letting him die. I mean, we just can't think that way in a civilized country. You
simply have a professional responsibility to do this, or you're saying the law would crumble.
We'd be a lot like some of these Eastern European countries that are having their turmoil when our system of law starts to fall apart. It's a sad thing. It's a terrible thing. But, you know, Mr. Dahmer killed, allegedly, a number of people. There's people out killing single people every day. You know, Dahmer becomes national news because of the largeness of it, but look at how many killings there are in this country.
But could you, as a citizen, as a former prosecutor, as a defense lawyer, and as a citizen, could you say tonight on this program to your colleagues in Wisconsin, get that part of the law back in which if you are found to have deviant behavior, you can be treated and you can be in confinement.
Obviously, in my opinion, it makes more sense.
Do you have any idea why that law was changed?
I don't know.
I know that you've made it clear, Mr. Boyle, that you cannot this evening discuss the plea, but you can discuss, I hope, because you were kind enough to fax me some material on the options available to take a look at.
That's academia. I don't have any...
but give us just a sense of what the problems are, because before the program we were talking about the fact that it is not a very happy marriage of psychiatry and the whole treatment model and then what happens inside a courtroom.
I happen to have been in the Milwaukee County District Attorney's Office when our law changed from the McNaughton rule, the right-wrong test, to the ALI test that Professor Herman was talking about before. And although he said it pretty well, he missed a very significant point. It is that you must first of all show that the person was suffering from a mental disease. That means psychiatrists have to say, this is what the disease was. And as a result of that disease, the defendant lacks substantial capacity to conform his conduct to the requirements of law or appreciate the wrongfulness of his conduct. If you have any idea how difficult that is, I mean, I can't tell you how difficult that is. And the fact of the matter is, people say, well, they're getting off because some lawyer is able to convince a jury. Very few people are found not guilty by reason of mental illness. Serial killers, single killers, it's used, and it's a very difficult plea because you almost have to have all the psychiatrists in agreement.
And that seldom happens, is that right?
Well, let me tell you what happens. I find 3 psychiatrists in a hypothetical case. They all say that my fella had mental illness. The state gets 3, and they say he didn't have a mental illness. Now you got 3 against 3.
He may have had a problem, but he wasn't mentally ill.
But the court appoints 3 independent psychiatrists, and the jury knows that they've been appointed by the court, and they don't belong to either side, and if they don't agree with the defense, you got an uphill battle.
Mr. Boyle, another hypothetical, because it goes to an issue about you that I think is interesting. Had Mr. Dahmer been accused of killing a policeman among his victims, would you have represented him?
Couldn't have.
Why not?
Well, I was an assistant district attorney and ended up being deputy district attorney. I knew probably half of the Milwaukee Police Department on a personal basis. I represented their union when I left the district attorney's office in 1968 for about 8 or 9 years. I attended the funerals of 12 Milwaukee policemen who were killed in the line of duty. I just don't think that I could represent someone who killed a policeman, and I don't know how anybody who had that, were accused of that, would ever think to hire me anyway.
Do you think that the city's getting a bum rap and the police getting a bum rap on this?
Let me take each, and I appreciate you asking. I left Chicago for Milwaukee, and I love Chicago. Milwaukee is Chicago of the 1950s, in which I grew up. It is as wonderful a town as there is in America, except for the weather. Weather's a little tough. The people are just magnificent. And I'm going to tell you, if there was a national report card, that police department would get an A, maybe an A+. And I think it very unfair for people to be criticizing the police department as a whole because of maybe a mistake on the part of some. And I don't even know if it was a mistake.
I'll let you finish during the credits, but Gerald Boyle, thank you very much for being with us. I'm John Callaway, thank you, and I hope tomorrow night you'll come back. Last week we had the top executives of the CTA on, and tomorrow night you'll hear from their critics here on Chicago Tonight. I'm John Callaway, thank you, and good night. So you're saying the facts may show a serious problem with police behavior in this case, but you say the police department in Milwaukee is basically a good one?
I did. I didn't say that this case is going to show a serious problem on the part of the police. I said the opposite. When all the facts are known, it may very well have been shown that the police didn't make a mistake. How do I know what all the facts are?
You're saying the jury's out on that?
The jury's out on that. I just think people just got to wait until they make judgments until they hear all the facts. Really, they really should. The other thing, though, is that first thing about me talking to the press. Press is relentless. When I talk to them, they quit calling me. When I don't talk to them, they call. And each day, instead of 30, it gets to be